Norman heard a noise. He proceeded towards the noise, and when he realized a masked gunman was in the room, he started running.
A masked man walks into a dental office in the middle of a Tuesday afternoon, chases the dentist through his own building, shoots him with a shotgun, and disappears. As he's dying, the dentist calls out a name, and it isn't the name of a stranger. It's the name of his own adopted son. The wife who was standing in that office when it happened would later be convicted of planning the entire thing, using that same son as the gunman to collect on more than $2 million in life insurance. Most people watch, then forget to subscribe. Don't be one of them. If you love true crime documentaries based on real cases, hit subscribe now because the next story could be even more unbelievable than this one. Like the video, comment your city or country, and let's dive into the case of Virginia Larzeller. Virginia Larzeller was married to Norman Larzeller, a dentist practicing out of Edgewater, Florida, and she worked as the office manager for his practice. On the outside, they looked like a comfortably established couple, a successful dentist and the wife who ran the business side of things for him. On March 8, 1991, at around 1 in the afternoon, a masked gunman walked into that dental office, chased Norman through the building, shot him with a shotgun, and fled the scene. Norman died a short time later. In the office when it happened were a dental assistant, a patient, and Virginia herself. Investigators eventually charged both Virginia and her adult son from a previous relationship, Jason, whom Norman had formally adopted after marrying Virginia. Prosecutors built their case around a specific theory, that Virginia and Jason had conspired together to kill Norman in order to collect roughly $2 million in life insurance, along with another $1 million in assets. The two of them were tried separately, with Virginia going first. What came out during her trial paints a genuinely disturbing picture of premeditation. Two men who'd each had affairs with Virginia during her marriage testified that she had actually approached them and asked for help in having her husband killed. Neither of them agreed to do it. Two other witnesses, Kristen Pomeroy and Stephen Heidel, were granted immunity in exchange for testifying, and what they described went far beyond a vague suspicion. According to their testimony, the night before the murder, Virginia sent Jason to a storage unit specifically to retrieve documents, including Norman's will and his life insurance policies. After the murder, she reportedly told Jason not to worry, that he'd get his $200,000 for, in her words, taking care of business. She apparently told both Pomeroy and Heidel outright that Jason had been the shooter, and that he'd messed up the timing, arriving a half-hour late to the office, which meant a dental assistant, and a patient ended up present for the shooting instead of Virginia being alone with Norman as planned. That, according to her own account to these witnesses, is why she had to fake it as a robbery afterward. Virginia allegedly directed Pomeroy and Heidel to get rid of both a shotgun and a separate handgun by encasing them in concrete and dumping them into a creek. With Heidel's help, police did eventually recover both weapons from the water, though they were never able to conclusively confirm the shotgun was the actual murder weapon. In the days following Norman's death, according to testimony, Virginia and Jason reportedly reenacted the killing together, with Jason playing the gunman and Virginia playing the role of the victim. Virginia gave police several different, conflicting descriptions of the masked gunman and the getaway vehicle, versions that shifted noticeably each time she was asked to recount the events. And there was the detail that arguably did more damage to her case than almost anything else. The patient who'd been present in the office that day heard Norman cry out just after he was shot, calling out, "Jason, is that you?" The financial trail investigators uncovered only reinforced the picture. Over the 6 years leading up to Norman's death, Virginia had taken out 7 separate life insurance policies on him. In the 6 months immediately before he died, she doubled the total payout on his life, from just over $1 million to more than $2 million. Norman had assisted in getting some of these policies set up, but the evidence at trial showed Virginia was consistently the one pushing to get them arranged. She'd also given false information to insurance agents along the way, telling several of them that older policies had already been canceled or didn't exist, or that they were simply being replaced, when that wasn't actually true. Shortly after Norman's death, Virginia filed a will that left his entire estate to her, a will investigators determined was fraudulent, and one that had reportedly been drawn up on the very same day one of the largest insurance policies on Norman's life officially took effect. In her own defense, Virginia argued that her shifting accounts of the murder were simply the product of grief and shock after losing her husband, that Norman had genuinely helped arrange every insurance policy himself, that the men she'd allegedly asked for help hadn't taken her seriously, and that Pomeroy and Heidel were unreliable witnesses who'd lied under oath. None of it moved the jury. She was found guilty as charged. At the penalty phase, no new evidence was introduced by either side. The jury recommended a sentence of death by a 7-5 vote. The trial judge agreed, finding that the murder had been cold, calculated, and premeditated, and that it had been carried out specifically for financial gain. He acknowledged that Virginia herself hadn't pulled the trigger, but gave that fact almost no weight, concluding she had been the mastermind who orchestrated the entire plan and directed everyone else involved. Virginia Larzeller was sentenced to death. Jason, tried separately, was ultimately acquitted of all charges against him. His trial had been moved to a different county because of how much publicity the case had generated locally, and an alternate theory was reportedly presented to that jury suggesting someone else, possibly Heidel, could have been the actual shooter. Whatever combination of arguments and doubt swayed that particular jury, Jason walked free while his mother remained on death row. Virginia appealed her conviction and sentence, raising more than a dozen separate legal issues, everything from how certain witnesses had been impeached to jury instructions, to an unrelated incident where a stranger approached jurors in a parking lot during the trial and made a threat that had nothing to do with the case itself. Florida's Supreme Court reviewed each argument individually in 1996 and rejected all of them, affirming both her conviction and her death sentence. The court specifically noted that the evidence showed Virginia had planned and directed the murder, identified Jason as the shooter, and personally arranged for the disposal of the weapons, and it found no reasonable possibility that any of the procedural issues she'd raised had actually affected the jury's verdict. That might have been the end of the story, except it wasn't. Years later, deeper problems with Virginia's original trial defense started surfacing during subsequent appeals, specifically involving her lead attorney at the time, a man named Jack Wilkins. According to appellate court records that later emerged, Wilkins had reportedly been consuming large quantities of cocaine and methamphetamine and drinking heavily throughout the period he represented her, all while allegedly hiding a significant amount of money from tax authorities. He was later convicted of 16 unrelated felony charges and served time in federal prison. Records also indicated he'd been romantically involved with the court reporter working on the case at the time. Citing the ineffectiveness of that original defense counsel, Florida's Supreme Court removed Virginia from death row in 2008 and resentenced her to life in prison instead. At that resentencing hearing, both prosecutors and her defense attorneys agreed to the life sentence rather than pursuing a full new penalty phase hearing that might have resulted in another death sentence being handed down. She remains incarcerated today at Homestead Correctional Institution in Florida. There are several smaller pieces of the original 1996 appeal that are worth walking through too, because they show just how many different angles Virginia's defense tried, and how consistently each one was rejected. One involved an attempt to attack Stephen Heidel's credibility directly, by bringing in two witnesses who would have testified that Heidel had a poor reputation for truthfulness. The trial judge refused to let that testimony in, on the grounds that the two witnesses had only known Heidel for a few months, through a very narrow social circle, which the court found wasn't a broad or reliable enough sample to establish anything about his general reputation. On appeal, Florida's Supreme Court agreed with that reasoning and pointed out something else worth noting. Defense counsel had already thoroughly picked apart Heidel's credibility during cross-examination anyway, bringing up an illegal identification card he'd used, a pending drunk driving charge, past instances of perjury, and lies he'd told police. The state itself even conceded to the jury that Heidel likely hadn't been fully truthful about the extent of his own involvement in the murder. Given all of that, the court found that excluding 2 additional character witnesses, even if that exclusion had been a mistake, wouldn't have changed how the jury ultimately weighed his testimony. A separate and genuinely strange complication arose after the jury had already reached its guilty verdict, but before the penalty phase began. A woman with no connection to the case approached 3 jurors in the courthouse parking lot and threatened to blow up one of their cars. The trial judge brought each juror in individually, with attorneys from both sides present, to find out whether the incident had affected their ability to remain impartial. Every juror said they didn't believe Virginia was in any way responsible for the threat, and every juror said it hadn't compromised their ability to be fair going forward. The defense tried to use the incident to argue for an entirely new trial, but the appellate court found no reasonable possibility the threat had tainted the jury's judgment, especially since it happened only after the guilt phase had already concluded. Then there was a controversy involving one specific juror, identified in court records only as Juror Kelly, who gave an interview to a writer after the trial ended, alleging a whole list of improprieties, that jurors had discussed evidence before formal deliberations began, that several had decided Virginia was guilty within the first week of a 4-week trial, that details about a plea deal involving Jason had leaked into the jury room, and that she herself had felt pressured into voting guilty. The trial judge interviewed Kelly directly, along with all 11 other jurors, and ultimately found her account to be inconsistent, unreliable, and contradicted by everyone else who'd sat on that same jury. The motion for a new trial based on her allegations was denied, and Florida's Supreme Court found no reason to disturb that decision on appeal. Virginia's defense also raised a broader fairness argument during sentencing, pointing out that 2 of the state's key witnesses, Pomeroy and Heidel, were never prosecuted at all despite their documented involvement in disposing of the murder weapons, and that Jason himself had been acquitted entirely. Florida law does allow a death sentence to be reduced if a co-defendant who was equally or more culpable received a lighter punishment. The trial judge specifically rejected that comparison in Virginia's case, finding in his own written order that she had been the dominant force behind the entire plan, that Pomeroy and Heidel had functioned as subordinates carrying out her instructions rather than equal partners, and that her role in orchestrating the murder made any comparison to their lesser treatment fundamentally unfair. The Supreme Court agreed, and specifically noted that Jason's acquittal, as a matter of law, meant he'd been formally exonerated of any culpability at all, which made him irrelevant to that particular comparison entirely. There's a broader piece of context that came out during those later appeals worth mentioning here, because it complicates the picture without excusing what a jury ultimately found she did. Biographical material submitted as part of her appeals described her own father as a chronic alcoholic who abused each of his daughters, with those close to her saying Virginia bore the worst of it specifically, because she tried to shield her younger sisters from him. She left home and married for the first time at 17, into a relationship her family later described as also marked by domestic violence. None of that evidence was presented to excuse the murder of Norman Larzeller. It was presented, years after her original conviction, as part of an argument about what kind of legal representation someone facing execution is constitutionally entitled to receive, regardless of what they're accused of having done. Now let's dig into what actually made this case work in court, and then what it reveals underneath all of it. The first technical thread worth examining is how heavily this case relied on co-conspirator testimony, specifically the accounts given by Pomeroy and Heidel in exchange for immunity. Florida law allows this kind of hearsay to be admitted under specific exceptions when prosecutors can independently establish that a conspiracy actually existed, separate from the hearsay statements themselves. On appeal, Virginia's team argued the state hadn't met that independent burden. The Florida Supreme Court disagreed, pointing to the broader body of evidence: the insurance policies, the fraudulent will, the storage unit retrieval, that existed entirely apart from anything Pomeroy or Heidel said, as sufficient independent proof that a conspiracy had genuinely existed between Virginia and Jason. It's a useful reminder of a general principle in conspiracy prosecutions, that testimony from a cooperating witness generally can't stand entirely on its own. It has to be anchored to something the state can independently verify. And in this case, the paper trail around the insurance and the will provided exactly that anchor. The second thread is the financial evidence itself, and how methodically prosecutors were able to lay out a paper trail spanning years rather than days. 7 separate insurance policies taken out over 6 years, with the total payout doubled in the final 6 months before the murder, created a timeline that essentially built its own motive, without requiring a single witness to explain why Virginia might have wanted her husband dead. Layered on top of that was direct evidence of insurance fraud, false statements to agents about existing policies, which did double duty at trial, undermining Virginia's credibility broadly while simultaneously reinforcing just how deliberately she'd worked to maximize the eventual payout. The third thread is the murder weapon itself, and an interesting gap in the forensic record that's easy to overlook. Despite recovering both a shotgun and a handgun from the creek, where witnesses said they'd been dumped, investigators were never able to conclusively confirm the shotgun was actually the weapon used to kill Norman. That's a meaningful limitation in a circumstantial case like this one, and it's part of why the testimony from Pomeroy and Heidel, describing the disposal of the weapons directly, mattered so much. Physical recovery of a weapon doesn't automatically prove it was the murder weapon. Sometimes the surrounding testimony about how and why that weapon ended up hidden becomes just as important as the object itself. The fourth thread is the victim's own dying words, which functioned almost like a piece of physical evidence in how the jury likely weighed them. A man calling out a specific name in his final moments, a name that matched his own adopted son rather than any stranger, is the kind of detail that's difficult for any circumstantial case to overcome once a jury has heard it, because it doesn't require any interpretation or expert testimony to understand its significance. The fifth thread involves the later ineffective assistance finding, and what it says about how death penalty cases in particular get scrutinized long after an initial conviction. The Florida Supreme Court's 2008 decision didn't dispute a single fact about what happened to Norman Larzeller. It focused entirely on whether Virginia had received the specific quality of legal representation the Constitution requires in a capital case, and found that a defense attorney allegedly under the influence of significant substance abuse issues throughout trial fell short of that standard, regardless of the underlying facts of guilt. It's a distinction that surprises a lot of people encountering a case like this for the first time. The idea that a conviction can remain completely intact, fact for fact, while the sentence attached to it still gets thrown out entirely, simply because the legal process used to arrive at that sentence failed to meet a separate, independent constitutional standard. Now for what this case reveals psychologically, because the sheer scale of planning involved sets it apart from most domestic homicides built around insurance motives. What stands out first is the extended timeline behind the plan itself. This wasn't a single, impulsive decision. 7 insurance policies acquired over 6 years, with the payout specifically doubled in the final half year before the murder, describes someone building toward a very particular outcome patiently, methodically, and over a period long enough that abandoning the plan at almost any point would have been entirely possible. The fact that it wasn't abandoned, that the plan instead accelerated as the murder approached, points toward a level of sustained commitment to the outcome that goes well beyond a moment of desperation or rage. The second layer worth sitting with is the recruitment pattern. Before Jason ever became involved, Virginia reportedly approached at least 2 other men she was having affairs with and asked them directly to help kill her husband. Both declined. Rather than treating those refusals as a signal to stop, she kept searching for someone willing to participate, eventually turning to her own son. That progression, working through a list of potential accomplices until landing on the one person perhaps least equipped to refuse her, a young man she'd raised, says something specific about how she likely viewed the people closest to her, less as relationships to protect and more as resources to be deployed toward a goal she'd already fully committed to. The third layer is what it meant for Jason specifically to be the one chosen. Whatever combination of loyalty, fear, or manipulation led him to allegedly agree to become the shooter, he was the one who ultimately faced a jury of his own, and he was the one acquitted while his mother was convicted and initially sentenced to death. Mother and son ended up on opposite sides of a courtroom outcome despite prosecutors' shared theory that they'd planned Norman's murder together. A genuinely unusual split that speaks to how differently juries can weigh the same underlying set of facts once they're separated into 2 different trials, 2 different sets of admissible evidence, and 2 different juries drawing their own independent conclusions. It also raises an uncomfortable question that the public record never fully answers, whether Jason's own jury genuinely believed he had no involvement at all, or whether the alternate theory presented in his trial, along with the shift in location and the passage of time since the original publicity, simply created enough reasonable doubt to acquit him regardless of what actually happened inside that dental office. Finally, there's the detail about Virginia's own background that only became part of the public record years after her conviction, a childhood marked by documented abuse, followed by an early first marriage also marked by violence. That history doesn't undo what a jury found she did to Norman Larzeller, and it wasn't introduced at her original trial as an explanation for the murder itself. But it does add a layer of complexity to a case that, on the surface, often gets reduced to a simple story about greed and infidelity. Whatever combination of financial motive, calculation, and personal history actually drove Virginia Larzeller's decisions in the months leading up to March of 1991, what remains undisputed, upheld by Florida's Supreme Court and never overturned on the facts themselves, is that she orchestrated her husband's murder and directed her own son to carry it out. It's also worth thinking about how differently this case would likely read to a jury today compared to how it read back in the early 1990s, given how much of the eventual outcome depended not on new facts, but on flaws in the original defense that only became visible years later. Virginia Larzeller's conviction itself was never seriously in question through any of her appeals. The Florida Supreme Court reviewed a dozen separate legal arguments in 1996 alone and rejected every one of them on the merits. What actually changed her fate wasn't a re-examination of the insurance policies, the storage unit run, the disposed weapons, or Norman's dying words. It was a much narrower, much more procedural question about whether the person representing her at trial had been fit to do that job in the first place. That distinction matters, because it means 2 entirely different systems were operating in parallel throughout this case. One focused on establishing what actually happened inside that dental office in March of 1991, and another, activated only years later, focused entirely on whether the process used to convict her had met the constitutional bar required before the state could actually carry out an execution. There's a kind of grim symmetry in how this case eventually resolved. Virginia Larzeller spent years building a financial structure around her husband's death, patiently and methodically, only to have her own legal fate ultimately turn on a structure she had no control over at all, the competence and sobriety of the lawyer sitting beside her in court. Norman Larzeller never got the chance to see any of that unfold. What he left behind was a case that took the better part of 2 decades to fully settle, first through a jury's verdict, then through a state Supreme Court's exhaustive review, and finally, in 2008, through a resentencing hearing that quietly closed the book on whether Virginia Larzeller would ever face the same fate she'd arranged for her husband 17 years earlier, a resolution that came not from any new doubt about her guilt, but from the slow, grinding machinery of a legal system finally catching up with a defense that should never have been allowed to represent her in the first place. More than 15 years after the jury that convicted her had already made up its mind about what happened inside that dental office in Edgewater, Florida, on an ordinary Tuesday afternoon that ended with a masked man, a shotgun, and a dying husband calling out his own son's name. It's also worth stepping back and thinking about how a case like this one gets discussed years later, once the original headlines have faded and only the court records remain. Most true crime cases that make it to trial settle into a fairly fixed public narrative, guilty or not guilty, closed. Virginia Larzeller's case never fully settled that way, because 2 entirely separate questions kept getting asked about it at 2 entirely different points in time. The first question, decided in the early 1990s and reaffirmed on appeal in 1996, was whether she had actually orchestrated her husband's murder. Every court that looked at that question answered it the same way. The second question, one that didn't even get seriously raised until years afterward, was whether the process used to sentence her to death for that crime had met the legal standard the Constitution demands. That question got answered completely differently, and it's the reason her story doesn't end the way most capital murder cases from this era typically do, with either an execution or a straightforward, uncontested life sentence handed down from the very beginning. There's also something worth saying about Jason Larzeller's place in all of this, separate from the legal outcome of his own trial. He was the son Norman formally adopted after marrying Virginia, which means the man he allegedly helped kill was also the man who'd chosen, years earlier, to legally make him his own. Whatever actually happened inside that dental office on March 8, 1991, Jason walked away from his own trial a free man, while his mother spent the better part of 2 decades moving between death row and a life sentence for a crime a jury found she had directed him to carry out. 2 people, 1 dead father, 1 surviving mother in prison, and 1 son who, by the legal record, bears no responsibility for any of it at all.